Hello and welcome to Free Speech Unmuted. My co-host is Jane Bambauer from the University of Florida Law School, and I am Eugene Volokh. I'm a senior fellow at the Hoover Institution at Stanford University and an emeritus professor at UCLA Law School. We're delighted to have with us Matt Lawrence, who's a professor at Emory Law School in Atlanta, and he has written extensively about addiction claims related to things like social media. And we wanted to talk to him about those claims, which are currently the basis of various lawsuits. Social media addiction claims and video game addiction claims are the basis of various lawsuits, as well as of various calls for regulation. So we wanted to ask him what his thinking about such claims is, and in particular, about how the First Amendment interacts with such claims, whether the First Amendment should protect social media companies or video game companies, and if so, to what extent against those claims, or alternatively, perhaps the First Amendment should be seen as encouraging those sorts of claims. So that's what we're going to be discussing. We're very glad to have Matt with us. He has written extensively on the subject. Jane and I think, are writing about it. I have an article in press, and I think Jane might as well. Let us say in press in the production process. But Matt is the one who has already written quite extensively on it. So Matt, tell us about your thinking on the subject.
Sure. And Eugene and Jane, thank you so much for having me on the podcast. And this is really exciting and a little intimidating. I did not come to this area as a First Amendment person. I've studied, I love the First Amendment and I've litigated First Amendment claims, but really my research interest has been addiction. And I was focused for many years on drug addiction, opioid crisis and drug addiction more generally. I worked at DEA. I have an article on the Controlled Substances Act. That's where I kind of came to this. And I was actually working on a project focused on um, drug addiction and state regulation and questions of constitutional limits on state power to prevent a person from getting a drug treatment. So I have a paper on that. You're addicted to a drug, opioids, there's methadone. It treats the drug addiction, but the state says you can't have that drug. You can't free yourself from addiction for various reasons. I had a paper looking at constitutional issues under the 14th Amendment, and that led me to state lottery gambling. So in Georgia, for example, you can't gamble legally, except that you can go to a convenience store and play a slot machine that the state of Georgia put there, or you can download a lottery gambling app that the state will allow you to use. And I became interested in that. And does that raise due process claims if the state is the one kind of getting you hooked on some slot machine without telling you even that it might be addictive? And once I started working in that space, questions about social media come up. Because when you try to draw lines between sports betting, slot machines, social media, Instagram, and then we could kind of keep going drawing lines. Novels, Sherlock Holmes released as a serial and the like. You start to wonder, like, what is really going on here, and what are the different regulatory paradigms? So I wound up focusing on slot machines first, and then social media second, because of claims that social media apps have been designed kind of intentionally to use tricks that slot machines use to foster compulsion. So let me first talk about like the idea of a trick. My kids watch a show called Bluey, which I love. And there's a Bluey episode where, do you know the claw? When kids go to like a pizza parlor, there's this claw game, and the mother tries to do a claw game at home, and the kid gets to steer her arm, and she just goes and grabs the stuffed animal right away, and the kids immediately lose interest. But then the father comes along, and that's not how you do it. Instead, the claw, the kid goes and it grabs the stuffed animal and raises up. It looks like you caught it. Looks like you caught it. Looks like you caught it, and then it drops it at the last minute. And now the kids are very, very engaged. And that's something going into gambling studies that's a near miss. It's just kind of known through a lot of research that if a person has the perception that they almost got the thing, that's more likely to get them grabbed in and want to not only play in the moment, but come back and play later. And there's allegations in the litigation against social media companies that they've designed similar sorts of tricks into kind of way that feeds are prioritized, the way they're built. And so, just to give you a few quotes that really interested me when I started going in on this, former president of Google, former CEO of Google said that the companies designed the machines to maximize outrage, and they play into the addiction capabilities of every human. That's Google CEO. Facebook president Sean Parker said the like button is intended to provide a little dopamine hit, and is a social validation feedback loop that exploits human psychology. And then video game programmer Jamie Madigan says that some of these tools are incredibly effective at making people keep playing because of how the dopamine-based reward circuitry works. And the engineer who designed Pull and Refresh says they worry it's addictive. And anyway, this got me thinking, hey, these are the same sorts of things I read about in how opioid addiction works and also how gambling addiction works. And when you talk to the neuroscientists, they're seeing parallels in the way some of these things work. So that got me interested in this space generally. Now, that has not answered your question about when can the state regulate. There's a lot of concern right now about social media addiction. And we could talk more about what I mean by addiction. There's a lot of concern about social media addiction and sports betting as well, and the sports betting apps that are proliferating. But when the state regulates opioids, there is no question about whether opioids are expressive. It's just a non-issue. So we don't really have to think about freedom of speech in that context. But when the state regulates social media, obviously we have to think about whether or not it's expressive. And so we've seen, as you would kind of predict, we've seen, as I understand they want to do, industry in the cases that get brought, so there's multi-district litigation, there's cases brought by attorney generals that are suing social media companies saying, you have designed these products to be addictive and you should have liability and things like that. That's one set of claims. And in those claims, the social media companies say, hey, First Amendment protects this. First Amendment protects this. And the courts are being forced to sort it out. And here is my understanding of the lay of the land, the doctrinal landscape for when a state that is concerned about social media addiction is kind of checked by the First Amendment in how they regulate. So first you have the question of coverage. It's just, does the social media, does the First Amendment protect at all? And on that question, you have the big picture question of whether or not a particular social media design feature, and I mean, because that's the Moody case from the Supreme Court, we're going to look at a particular design feature one at a time. We're not going to ask, is social media expressive? For coverage, we're going to ask, is this design feature expressive? And we have to ask, is it expressive? And then if it's expressive, then it may qualify for the rest of the First Amendment protection, as long as it's not gambling, because gambling is not protected by the social media, by the First Amendment. So the sports betting app does not get to go argue that the way it's built prop bets is expressive, that there's just an exemption for gambling. Now, I think that with smart thinkers like you two, we might get to a place where we can have a unified approach where gambling gets folded in to the rest of the analysis and we don't treat it as sui generis. But at least right now, you have that first question. Is it expressive and is it not gambling? If it's expressive and it's not gambling, then you get to the question of, is it content-based or content neutral? If the regulation is content-based, then we might be in big trouble. It might be very hard to do that regulation. And we saw the Ninth Circuit just had its decision about the California addictive feeds law, where it said the regulation of the like button and engagement counts, that's content-based, that doesn't fly. So content-based is going to be very, very hard to fly. On the other hand, if the regulation of the social media function is content neutral, and of course we can talk about what that means, but if it's content neutral, then it could potentially pass muster, but there has to be a sufficient state interest. It has to be narrowly tailored. And there's also questions about overbreadth and over-inclusiveness and the like. So that's your kind of standard kind of test at that stage. Let me go back up top. Coverage. I said it has to be within the coverage of the First Amendment for us even to think about this. So there are regulations out there, like if there's concern about social media pushing pro-anorexia content to somebody who its algorithm knows is anorexic or has struggled with anorexia, which is a thing that happens and is alleged in the suits and is out there, at least alleged in the suits, right? If a state comes in and says, you may not display pro-anorexia content, then you're within the coverage of the First Amendment. You're talking about the kind of expressive choices of the app. And so we'd have to go through the rest of the analysis on that front. If, on the other hand, the state comes in and says, there's these issues of near misses, like if there's kind of this, if we're playing with the timing of a notification, or if we're not telling somebody about consumer protections that are available to them, or we're using intermittent reinforcement and variable reward in how we space out content, then then you're not allowed to do that, at least not without telling people. There's arguments that that is content neutral. And then if it's content neutral, then and it's not gambling, then oh, sorry, I got mixed up. There's argument that the regulation of something like intermittent reinforcement is not expressive at all because the kind of timing of things is not displayed to the user. They don't know what's happening. It's not expressive at all, and so then it just does not get First Amendment protection. But if it does, then it goes under the content neutral category. And then the last thing I will say of all of this to the two of you is that um, um, when we talk about the state interests involved, um, I have found here that um, that you have a menu for a state of very broad state interests to more narrow ones. So sometimes states are asserting that they can regulate this because of interest in protecting psychological well-being of children, or interest in just the public health, which is the Jacobson case. These are potentially very broad interests. On the other hand, you could also have a more narrow interest. So if we say that the concern here is actually the addictiveness, then the state interest could be just in protecting the freedom of thought of the user. It could be in protecting that kind of freedom from addiction. And then what the state can do to support that interest is more narrowly constrained. So you have to map out that question too. So um, that's a broad lay of the land. If you had my piece of paper in front of you, it would be easier to track. And I'm thinking of listeners who don't know First Amendment law kind of very generally, um, but the bottom line is just coverage, not gambling, and then this content-based versus content-neutral distinction before turning to the nature of the state interest.
Got it, Nat. Thanks so much. Very helpful layout. So you explain why it is you think that there is some justification for regulation here, and then talk about where First Amendment prohibits certain kinds of even justifiable, or excuse me, certain kinds of regulations for which there is a plausible justification, but it only applies to things that are that are expressive in some sense. We can talk about that, and it also provides more latitude for the government to restrict speech in content neutral ways rather than content based ways. So on those big pictures, I think we all agree. I'd say also, I don't know about Jane, I'd say also I agree with you with regard to the gambling. It's true that gambling transactions, like any kinds of commercial transactions or transactions involving exchange of value, tend to involve communication. But just because a bingo game involves people saying a lot of things, or for that matter, a poker game involves people saying things and displaying visuals, the cards, um, uh, doesn't mean that the First Amendment precludes gambling regulation. So on that, I would
And then
agree.
I was gonna say the same thing. I actually think it's such an easy case because it's really a transaction. There's a
Exactly.
transactional hook. And
Exactly.
so, much like how the regulation of drugs, like you could say, like, a peddler of LSD is trying to give someone this very communicative in some sense experience, but
Right.
the fact that it is a substance, just crosses that speech conduct line well enough that I think it's very obvious. Whereas if there were a law, though, that targeted gambling based on no money, so it was just the fun of playing with fake currency that has no actual financial or other real world um, um, interest on the users, then I think that there would be no transaction that would be non-communicative. So that was my impression too. Yeah.
Yeah, I think that if we accept that gambling is simply not covered by the First Amendment, then questions come out about how we define gambling. You've each articulated kind of features of what you see as gambling. We could then ask how those features connect to our constitutional methodology for defining a concept like gambling. I would suggest that we should also think about the kind of underlying concerns that behavioral addiction to gambling presents, and that we, in thinking about the definition of gambling, would want to also include practices that are part of gambling and a part of other things that raise those same concerns. Others would disagree with that, but I think we just get to interesting questions there about boundary drawing.
So far we've talked about things that we were largely agree on. Here are some things that I think we might disagree on. So, Matt, I wanted to ask you this. Um, my sense, as a general matter, is that when it comes to First Amendment related activity, and of course, it's an interesting question how far that should go. we basically think that people should be free to decide on it, free of the government intruding. And that includes situations where we think people are making bad choices about what what to hear and what to do based on what they hear generally. It also extends to situations where we think they're being psychologically manipulated in certain ways. Um, to be sure, in certain situations may not be, like, for example, with fraud, if it's outright fraudulent obtaining of money, sort of related to gambling, where gambling that involves exchange of things of value, there are permissible restrictions on that. But as a general matter, when people say, I've been manipulated by this speech, we generally think, that's kind of on you. That's not for the government to protect you against. And here's an analogy I want to draw, and I want to acknowledge that, like all analogies, it's not an identity. But it involved the First Amendment, but a different clause of the First Amendment. That's the free exercise clause. That there are a lot of people who invest a great deal of time and effort and psychological and have a great deal of psychological investment in their religions. In fact, they often spend a lot of money on their religions in the form of tithing, maybe providing 10% of their income to the church, or sometimes even donating much larger sums of money. In fact, some people turn over all of their property either to the church or surrender it to someone else, take a vow of poverty. They sometimes deliberately cut off connections with their families because of their religion, whether it's because they think that their family are sinful in not following the right religion, or they may love their family, but they may conclude that they need to join a monastery or even become a hermit and separate themselves from their family in this way. Um, so also, I take it that a lot of people, and I don't necessarily want to endorse this view generally about religion, but I think it's probably true at least to some religious beliefs. A lot of people think that some religions act in manipulative ways, that they prey on people's emotional vulnerability. They may indeed, without sort of thinking of it in terms of dopamine hits, may indeed engage in this kind of I guess, a reward reinforcement. They kind of are deliberately create habit forming, or deliberately engage in habit forming behavior, deliberately create habits of prayer, habits of visiting the church, habits of giving money to the church. And one could imagine, I think, the same kinds of arguments about manipulation, about preying on the vulnerable, including sometimes preying on minors, that one would apply to religious to the actions of religions, including to the religious preaching in favor of particular things, or the way the religion builds its community. Um, Yet I take it that if somebody were to say, all of the stuff about how you're being taught to pray every day, that's kind of a religious manipulation. That's something that kind of pushes you to do these things repetitively. They get you into habits. We know that once people join a religion, they sometimes find it very difficult to leave. They sometimes do things that are bad for themselves and for their family lives and for their financial outlook. We think it's all very suspicious. So we're going to either restrict some of these behaviors or require warnings. Like, before you're asked to tithe, you have to provide a warning this behavior may be habit forming, warning the Surgeon General has concluded that some such behavior may be manipulative. I take it if we were to try to do that, the response would be probably the free exercise clause precludes that. That free exercise clause includes the right to try to get people to adopt a certain religious belief system and engage in certain religious practices, setting aside one, like if it's religiously motivated murder, that might be a different matter, but engage in certain religious practices without secular authorities, whether prosecutors or courts or juries, either in civil or criminal cases, or executive or administrative officials, second guessing the church's behavior and saying, oh, this is too manipulative. This relies too much on what we know now about the neuroscience of dopamine release. This has been carefully honed, to be sure, not through a couple of years of A/B testing, but through thousands of years of the evolution of this church, of this religious belief system. It's been carefully honed to take advantage of people's reliabilities, advantage of people's vulnerabilities, and irrational approaches to things. Uh, that would be pretty clearly a free exercise clause violation. So if I'm right on that, maybe I'm wrong, but if I'm right on that, why wouldn't similar attempts to try to restrict communication be also a free speech clause violation?
And can I do a version of that question that's very similar but brings it into the free speech clause? Or do you want to first respond to? Well, so I'm one. You could say the same thing. I was thinking the same thing about the news or political speech, right? So if the news has long known that if it bleeds, it leads, that there's fear mongering that causes certain psychological responses that keep people coming back more often. Demagogues certainly do their own experimentation, sometimes pretty close to A/B testing with the help of staff to figure out what types of messages keep people at almost religious like fealty to their campaigns. And so that would be very similar, I think, to what Eugene's asking, but in the free speech clause. All right, your floor is yours.
Let me give a really short answer and then try to do a longer answer. I love these questions, so thank you. And I wish we had more than an hour. So my very short answer is that if the state were to say that to single out a practice used by a religious institution and say, this particular practice we think is concerning as a public health matter because it contributes to addiction. And so we're actually banning that practice society-wide, including when used by religions, right? If a state were to do that, then that would be Oregon v. Smith, which is when the state banned peyote use. And the Supreme Court said that the state could apply that ban to a religious institution, and it did not violate free exercise. So if the state is across the board identifying a particular practice or particular mechanism as such a threat to people's freedom of thought that it leads to addiction, and it's putting that ban across the board, then it can apply as well to churches and as well to individual religious institutions. And we know that that's not a violation of the free exercise clause under Oregon. Now, RFRA would be different. RFRA, we'd have to do a whole analysis, but it would be different. And then to go to kind of, to unpack that answer a little bit, what I love about this question is that usually when I talk about addictive design by social media companies, or in slot machines or anywhere, usually when I talk about it, people kind of say, "What are you talking about?" There's, sorry, we're gonna have to edit for a sec. My phone rang, or you cannot edit, and readers can hear that happened, or listeners. Anyway, when I talk about this, people say, "What are you talking about? There's free will, and if we follow your logic, then all of these things that happen in society might actually be influencing our brains and changing the way we think. And maybe there's not free will; it's all deterministic. Like, what do we do with that? Where do we go there?" And your question does the opposite. You say, hey, here's this beloved institution of religion that is actively manipulating us. I'm grateful for the way I was manipulated as a kid by religion and the values it inculcated, right? And so this is coming from a completely different angle that's like the Bethel tinker kind of thing about, well, we know that we're inculcating. And sometimes we want the state to inculcate civic virtues. And then, of course, religion is there inculcating. It's shaping people's minds and the like. And so I appreciate that. What I would say is, even in a world where we know that the conversation we're having right now is going to shape the way we all think in the future, and that we don't really have freedom of thought, our thought is constantly being influenced by the people we're exposed to, even in that world, addiction is a different thing. It's a different thing because historically and traditionally, we've thought about it as a different thing. It's a different thing because when the neuroscientists study it, they can show pictures of it in your brain and show how it changes brain structures in different ways. It's a different thing because even if it's a more extreme version of habit, it's different in kind to the point that we treat it differently medically. We think about it differently in society. And that last answer to why addiction is a different thing, I'm getting at, it might be that addiction is a different thing in degree rather than in kind from other things that we're exposed to in life. I think that's actually a current debate in some of the, at least in the anthropology community, if not the medical community. But addiction is a phenomenon that is distinct. Maybe so is religious belief. I'm not sure, but I do think addiction is a different phenomenon that is distinct. And so then I would say, to distinguish your religious examples from addiction is, well, your religious examples are about inculcating religion. For example, in most of those, or if not all of them, either the parent wants that inculcation or the person who engages in the practice wants to engage in the practice. Addiction, on the other hand, is something that a person sees as harmful, or maybe that medicine sees as harmful. And addiction's got intrusive urges to engage in a particular behavior that's unwanted. So if the state labels a particular practice as causing addiction, that's a thing, that's an outcome. That could be a religious practice, to go back to where I started. In that case, if the state targeted religions and said only religions cannot engage in this, then that would be a blatant violation of free exercise clause. But if, on the other hand, the state says no one can do this, or it's always regulated in this way because we think it leads to addiction, that again would be Oregon v. Smith. That's a case that we already know the outcome to. And then let me just say a third thing that I'm very concerned about, which is the state using these tools, right? So the flip side of free exercise is establishment clause. We have a long history of concern about the state using some of these tools to inculcate certain things. I am concerned today that the state will gain control over social media companies and use these tools to determine what people think and influence them. State action may or may not protect that. But if you say that addictive design on social media is no different than, like, reading a book or something like that, then the kind of government propaganda, government speech cases would say that a government can also manipulate somebody to be, hooked on the government version of Facebook and pay taxes through the government version of slot machines and all of that. So I am concerned about the kind of flip side of some of these equivalences if we draw them. So, but anyway, that's my best answer to a question that had a lot of subtleties to it.
Well, before we go to the equivalent of the establishment clause, let's go back to the line drawing, I guess, between addiction versus other things that influence people. And I get what you're saying is that if there's some sort of medically trustworthy gauge for addiction, and we can safely draw some kind of line and say anytime someone is anytime a company or a person is engaged in addicting others, that can be regulated. I guess I still don't understand how the social media lawsuits could work on those terms, because I really feel quite confident that the news would fit this model of, if social media fits this model, I think the news does too. So how can a state AG go after only social media and not every speaker that engages in these practices?
So the question is, hey, don't people get addicted to following the news in that sense? And might that be something medicine or whoever we are judging this by says, yeah, that happened. And then what does that mean for regulation?
Right.
First, I would say it's hard for me to imagine a regulation that targeted news outlets that wouldn't be targeting expression and that wouldn't be content based.
Well, no. I mean, what if it's that we know that the news organizations, they've looked at their audience figures and they've realized, oh yeah, exactly what the social media companies have figured out, right? That rage bait and fear baiting, those work way better than the other stories. They're going to keep delivering those. So I think that the media, that the influence of the internet on the media and the sort of 24-hour news cycle has made both social media and traditional media have to run these models in order to sort of survive. If I'm right about that, maybe we disagree on that, but for a minute, let's assume that there's something similar going on. Yeah,
I do agree, and actually, that just connects to a side point, which is one of the challenges of addictive design is that it's not that people wind up consuming more speech. It's that they wind up consuming the addictive speech to the competition, to the kind of cost of the normal speech, the relationships, the human interaction, the novel reading. And so this isn't just a question of how much speech people consume, it's whether in our marketplace of speech, the winners are the ones who outcompete by being addictive, or
Right.
the winners are the ones who outcompete with being stimulating or controversial or the other things that might garner people's attention. And that's a real
Right.
challenge we have in the social media landscape right now is that if you had an idea for a great marketplace of ideas kind of social media app, but you declined to do things that were going to develop compulsions in users, then you wouldn't be able to get the number of readers, the number of users to get to that network effect. And this has antitrust implications and everything. But so it's not just a question of how much speech people consume. It's like what kind they consume. And I take your
Right.
point that like maybe someone singing the song I'm singing would say, so we should come in and stop news outlets from leaning into rage or leaning into fear or some of these things that, we could cite Cicero or somebody on these things grabbing grabbing people. Um, my answer to that is that it's hard to imagine that regulation not at least coming under First Amendment coverage as a regulation of expression. It's pretty hard for me to imagine it not being content based. Like if you said you can't have outrageous speech, that's content based. And so now we're fatal in fact strict scrutiny. If on the other hand you told me, hey, what if I regulated a news company and I said you can't use personalized data in your targeting decisions, which is the sort of regulation we'll
Mhm.
see of social media companies. In that case, I'd say, well, is using personalized data uh, is that expression? And I think there's a good argument that it's not expressive to use personalized data. And then even if it were expressive, is that a content-based restriction? No, it's not. It's not based on the content they're putting out. It's on their inputs.
Why isn't near misses? Why wouldn't near misses then count as expressive? Or the near miss? I thought you were arguing that the design features that are like exploiting things like near misses would not even be counted as expressive. Is that
Yeah,
right?
yeah. So yeah,
This,
for one example, if the user like a near miss works because the user doesn't know that it's happening. Like they think it's real is what I'm getting at. Another allegation that's out there just for the help of this conversation. One of the allegations in the complaints is that I forget which social media company actually. I think I know, but I'm not going to say because I always try to be cautious about these things. That one of the social media companies they come up with a ranking of how much you'll like given content,
Mhm.
and then they don't give you first best, second best, third best, fourth best, fifth best, just in order like that. They give you first best, boring, boring, second best, boring, 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 third best, boring, 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 boring. They make it like a
Mhm.
slot machine that you're constantly pulling to refresh, where the jackpot is stimulating content and that is playing into the exact. We might say it's not value that you're getting, but it is. It's utility, right? And so it winds up running to the same kind of psychological mechanisms. So some of the regulations would say, hey,
Mhm.
you can't do that. Or a person has to be able to, the law would say a person has to be able to opt in to a, a social media site that's going to do that. So they have to be told, we're not giving you your most interesting content. We are intentionally spacing content. In fact, our algorithm predicts when you're going to leave the app, and we then give you the very juiciest content we've been saving for that exact moment to keep you going, to keep you going. We're going to do that. Do you want to opt into that? Because it's exciting and it'll get you hooked and you won't be bored. And then the person could opt in. That law, is the one that I would say, hey, well, that's not a regulation of content, da, 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 da. But that certainly the social media companies would say, wait a second, that's a regulation of speech and, there's a state interest and you shouldn't even be able to empower consumers to know whether being exposed to that kind of a slot machine trick. That law should be off the books. And that's the sort of thing where you can tell I'm trying to describe the way the law is, but I do have a sense that we need a more subtle analysis for something like that might allow informed law where the evidence supports it.
Matt, I want to return you a little bit though to the religion example, and I think it's noteworthy that you're saying that religious practices could be regulated as well, so long as there's this general general rule. Um, well, so imagine there is a general rule that says you have to disclose to people whom you're seeking to join your your listener group, whether it's religious or not. Like, how is it that you select what you're going to say to them? And also a rule that says you cannot select things that are targeted based on what you know about them. So if a religion wants to approach someone with sort of a generic pitch, Could be fire and brimstone, could be love and acceptance, could be any mix of that. That's fine. But if a minister or just a member of the group acting in the direction of the group takes advantage of something they know about you. I see you're a rich man. Have you wondered about whether your riches interfere with your spiritual progress? I see you're a poor man. Have you wondered if God loves you any less, and that's why you're poor? Or I see you're elderly. I see you're sick. I see you're a man. I see you're a woman. That kind of stuff. No, 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 no. That's not legitimate way of pitching your ideas, whether they are entertainment, whether they're political ideas or religious ideas. Sounds like you are saying that that would be a constitutional restriction. Now, I think as a doctrinal matter, I don't think Employment Division versus Smith goes that far. Among other things, rightly or wrongly, Employment Division versus Smith did expressly distinguish situations where there's a mix of religious practice and some other right, whether parental rights or speech. So I would think that a regulation of religious speech, even if it is framed as religion neutral, and even if it's framed as content neutral because it's just based on whether your targeting is based on a person's attributes, I think would be subject to strict scrutiny, even following Employment Division versus Smith. And certainly it does look right now that the Supreme Court, at least six, right now of the currently sitting justices, at least five justices have said they'd be willing to reverse Employment Division versus Smith. By the way, I'm a fan of Employment Division versus Smith generally, but that's not where I think the court today is. But even under Employment Division versus Smith, I would think that that kind of regulation would be unconstitutional. But what's more, I just think it just would be a striking interference by the government with the liberty of organizations to try to convey their message, including in ways that some might conclude are psychologically manipulative, but others might conclude are actually quite valuable. Many people would much rather hear messages that are pegged to their circumstances than are just generic and applicable to everyone else. So, so can you elaborate a little more? Maybe I'm wrong. Maybe I'm misunderstanding. Maybe you think that this kind of religious behavior would be protected. But if your argument leads the religious behavior like that to be unprotected, to be regulable, at least so long as that's the same way we treat social media platforms and even news organizations as to their kind of individualized targeting, then it just seems then that your proposal is quite inconsistent with the way we've generally done things when it comes to First Amendment protected activities.
If Pope Leo has the Catholic Church devising a Catholic social media app, um, and they go to think about how they're going to prioritize content and how they're going to make recommendations to keep Catholics engaged, they have to ask what sorts of data can we consider as we do this, and take addictive design out of it. I'm guessing that they say, well, we're not going to be allowed to use data that is HIPAA protected medical data, and we're also, well, you're squinting, Eugene, so we'll come back to you. But
Yeah.
I'm well, take as a first cut that there's existing limits on the sort of data that someone designing an app like that is allowed to um, consider and use
I'm
as an
sorry, I'm
input.
not sure we should take it as a given.
Okay.
For example, HIPAA, would apply if, for example, there is a Catholic hospital. If it's sort of the church says, "Oh, Catholic hospitals, please pass along all the information on your patients so we can tailor things." Maybe that would be applicable, but that stems
But
from the
but so you're
peculiarity
but
of the
yeah.
doctor relationship. If the law said you as a priest, you may know that your patient is suffering from cancer, but you can't approach the patient and say, I understand that you're ill and you must wonder, like, where is God in all this? And let me tell you, here's how you should reconcile the reality of your illness with God's love. If that were something that the law tried to
Yeah,
restrict, I would think that would be a pretty clear constitutional violation, no?
and I think you're right that HIPAA does not govern the content of third parties. So HIPAA is a bad example there. I'm just trying to think of, and maybe you can help me
Generally
out. But
applicable law is what you're saying. Like the
if
app
I
would have
went to a
to.
yeah, could the Catholic Church go to a data broker in some foreign country and say, "Hey, there's all this stuff that was breached about Catholics. We want to buy it from you because we want to do better tailored algorithms." That presumably there's some law. Maybe I'm wrong. RICO or
Complicated.
something like that that might well limit it.
It's
Wouldn't we?
complicated. Bartnicki v. Vopper makes it complicated. But but I'm sorry, but I'm interrupting. Go on.
Oh, but and then I would also add non-discrimination laws that generally applicable non-discrimination laws that say maybe don't discriminate on the basis of sex or something like that. If the
Well,
Catholic
the
Church,
Catholic Church does discriminate on the basis of sex, including in hiring. And it, as well as other religious institutions, are exempt as a First Amendment matter from non-discrimination laws
well,
in hiring. Even though generally saying we only hire men as priests or
no,
men
and that,
employees would be generally unconstitutional, they
yep.
do have right under the First Amendment to do that.
Yeah, and this is where
Presumably,
I'm going because as I recall the case, it's you have a generally applicable statute that's not necessarily doesn't necessarily exempt the Catholic Church from say like employment discrimination rules or something like
Mhm.
that. And then the court says, wait a second, this generally applicable law may be fine for plumbers and social media
Mhm.
companies and
Right.
everyone else, but were we to apply it to religion, it would run into special free exercise and establishment clause issues. Therefore, we're going to serious constitutional question. We're going to avoid that reading. And the upshot of that kind of a case is that we're pretty comfortable in our law with generally applicable rules that apply to all sorts of people and institutions. That if it applied to a church, it might make us nervous. Is
Oh,
what I'm
but
getting
I'm
at.
sorry. I thought earlier in your praise of Employment Division versus Smith, you were suggesting that actually these kinds of anti-addiction rules could constitutionally apply to churches. They don't get any free exercise clause break any more than social media platforms should get a free speech clause break.
Yes.
But
No, you're right. I
it's okay if you change your view. I mean, either because
no.
I misunderstood, or maybe it's okay if you
Yeah.
explain to me I misunderstood your view. But if you change it, that's fine too. I mean, it's great
Yes.
that to
No,
have
Eugene, and
these
I'll
kinds
be
of
honest,
suggestions.
I have on my notes, which aren't great, but I wrote religion question mark. And then I have just two really distinct ways that I think the religion analogy kind of is only so helpful. The first is that it runs into the free exercise Oregon v. Smith issues that we've already thought about. The second is that this kind of analogy to religion, social media companies to religion, sort of assumes that if we can't do something to a religious entity, we can't do it to social media companies and vice versa. And in fact, our law is just very, very, very comfortable with treating religious institutions differently than other institutions. And that case, that example of reading a generally applicable law narrowly only to create an exemption to religious institutions is just an example of how comfortable our law is with religious institutions being different.
So I appreciate that, but in addition to religious institutions being different, speech institutions are different too. The Boy Scouts prevailed in their challenge to a non-discrimination law, even though they have a religious component to it, but they prevailed under a free speech clause challenge. And likewise, there are cases that actually say that speaking organizations may in fact discriminate based on race and such in choosing people whom who are going to be on screen. There was a case involving, I think, The Bachelor, which was accused of discriminating based on race in selecting the contestants, and the district court said, well, they're entitled to choose based on race whom they depict on screen. So what I'm saying is, we recognize that religious institutions are protected by the free exercise clause, but we also recognize that speaking institutions like social media companies are protected by the free speech clause. So my suggestion is that if we recognize that the same behavior that we might label addictive when it's done through religious institutions and in a way that involves probably a lot more money in many ways than the typical social media platform, at least in terms of how much people give, that is something that can't be restricted given the free exercise clause. Maybe we should say the same thing with regard to the free speech clause, as opposed to gambling, as opposed to drugs, things that aren't protected by the free speech clause.
Well, I just look, Eugene, if it would be helpful, I could put the third thing I have in my notes, which is,
Please.
that I agree with you that social media companies are protected by the free speech clause. The question is, what does free speech protect? And so first we have to ask if a given regulation is within the coverage of the First Amendment or not, decide whether it's regulating expression or not. But even if it's regulating expression, we then check if it's content-based or content neutral. And then finally, and just go to the religious entity. So let's say it's a regulation that applies to a religious entity, and we say it is expressive. And let's say it's content neutral. Then we have to talk about state interest. any state interest that's focused on protecting people from religion, or protecting people from being manipulated by religion, I would think it's going to be a non-starter to a court, that they're not going to be interested in that state interest because of the Establishment Clause and the Free Exercise Clause. On the other hand, if you get to that stage and the state says that it has a general interest in, say, the psychological well-being of children or something like that, then I think we're back at an Oregon v. Smith kind of analysis when it comes to religious institutions of asking whether or not that violates free exercise clause. But only the religious institution can make that argument. Facebook, unless and until it claims to be a religious institution, can't make a free exercise clause argument. It has to try to fight a state interest in protecting the psychological well-being of children on the merits. And just another example of that is Jacobson. Jacobson is forced vaccination. So here we're not limiting somebody's speech, we're actually putting a syringe in their body in order to vaccinate them. And the Supreme Court says, yes, you have a state interest. I'm sorry, you have a liberty interest, but the state's interest in public health justifies that. So we wind up winning after scrutiny. And nonetheless, state after state after state exempts religious institutions from that mandate because they recognize that if somebody has a sincerely held religious belief against vaccination, that's kind of a different kettle of fish. And so that just goes to, kind of my point here that we're pretty comfortable that sometimes we have to give a wider berth to religion because of its unique place in our history, tradition, and culture. That doesn't mean we also have to give the benefit of that unique place to social media companies. And in fact, I come back to the power religion has because of how it tries to inculcate and steer people, like illustrates the power that social media companies can wield as they design their apps, and kind of is what motivates, I think, people to think that there might be a justification for some kind of state regulation, assuming that there's an evidentiary basis and it satisfies the requirement of the framework.
Can I actually? Well, I'm going to take us back to like sort of thinking about addiction as what's so special about addiction in terms of its relationship to free speech. It seems to me that what makes this hard, you are categorizing these arguments as the sort that actually help people's freedom of thought. Um, and I will agree with, let me go to some examples where I think I would agree with you and then show like sort of the limits of it. So if there were a virtual reality device that was so effective that even though it was only using photons and sound waves, it just created the physiological responses or somehow kind of hijacked, it was so effective that it would hijack decision making. I would say, okay, it no longer matters that these are media, it uses media of communication. I'd say it's like a drug at that point, right? So there's some point at which purely communicative technologies, I think, could have the effect and result that somehow bypasses free thought. And then I would be in the same land that you are. I'd say, okay, it's regulatable for the same reason that drugs are. Social media to me just seems so far from that. And so I'm wondering if you could help me. I mean, I think it would be useful if I could, test where you are on that spectrum by asking you to say a little bit about pornography, where a lot of these same arguments were made about, 3 decades ago or so, 4 decades, um, and video games. Um, yeah, I think starting with those two. So, like, given that the First Amendment, that the arguments that uh, tried to be made, saying that pornography sort of bypasses the sort of higher order, thought and is really more conduct than speech. Those were not persuasive. Um, so why should social media's similar arguments be persuasive?
Yep. And yep. So first, for pornography, to me, just it's content based right from the start. We're talking about a particular type of content, and then the defenders of regulation in that space um, are saying, uh, well, but there's a different history and everything like that, and because it's content-based, it just seems very different to me than some of these questions about the design. I guess it would be similar to someone saying pro-suicide content or pro-anorexia content is just inherently captivating, and then the person can't get away from it. I think it would be analogous to that, but that's not what I'm talking about. I'm talking about the kind of way the app is designed and the way it presents material, like how it times out the material it presents, and the infinite scroll and the pull to refresh mechanism and things like this. And so
Okay.
Oh,
And
go ahead.
that's a distinction you were making before, but I still don't quite see it. So would a cliffhanger, like when a new television show leaves a cliffhanger to get you through the
Yeah.
advertisement, is that a
I,
design feature or is it
you
content?
know, I kind of love cliffhangers as an analogy because they keep us reading. We all know what they
Yeah.
are. It has a name. I think at
Yeah.
50 years, a lot of things that we and our kids experience in social media will have names like cliffhangers, and we'll all know about them. And then we'll be able to say that there's kind of consent just because we already know about it coming in. Like we know that that kind of device has that kind of a thing that we don't have today. That's another version of me saying, which that um, we like kind of understand how cliffhangers work. So even if my argument got to a space that said there ought to be a thing on the front for parents that say, warning, before you give this to your 6-year-old, it contains cliffhangers, right? I actually think when it says like can't put this down, that kind of thing, people know that, right? And they want that. They want to encourage more reading and that kind of thing. So um, I think
Mm.
that I think that cliffhanger falls in the category um, like the timing of the reward, spacing out the exciting content, where I think we could have a very interesting fight about whether that's expressive or not. And then
Okay.
there's things that just don't fall in that category at all, like pull to
Like
refresh and things like that. No, and no, yeah, and
or
then pornography is clearly
pornography.
content based.
Okay.
Pornography is clearly content based. Um,
Okay.
so that's how I would think about those. If I could just add a thing of what you started with, Jane, which is that like this device that was like just totally addictive or mind control, and that you would be with me. Um, I would just make a pitch that, especially for people who love the freedom of speech, that when you have this conversation with somebody who's in their 20s, they know that device exists and they've felt addicted to it, and it's like TikTok. And so they have personally wrestled with this. And if you just go in the App Store and search social media addiction, or go search in Google, quit social media, right? To talk to a 20-year-old about how often they've deleted their social media app and then reinstalled it 2 weeks later, and then not wanted to, or other steps they've taken. I think we have a generation coming up, this is just my perspective, that is already there with a lot of these social media apps because they had experienced it. They've experienced compulsive use that interfered with their studies, that interfered with their lives. Many of them see themselves as in recovery from this. And here I would say those people are going to be very supportive of regulation in this space. And it can go two ways. It can go for such people, public health regulation, this very broad thing, or it can go, we're regulating addictive design. We can regulate intermittent reinforcement. In that world, which we might be in 20 years, the addictive design route is much more speech protective as a justification for regulation in this than the other route that will be very tempting, which is just public health, or like Justice Thomas might say, it's parental control over speech. And that, so just you can do whatever something like that. So I don't think this is all like pro-free speech, anti-free speech here. I actually think there's an extent to which, or lane through which, focusing on the addictiveness winds up being more speech protective overall, even if it does require some give from free speech advocates.
All right. We are coming on the 1 hour mark, and unfortunately, our listeners are not addicted. If they were, we could 3 hours, and they wouldn't be able to put it down. And engaging and interesting as this has been, there is a limit to their patience, regrettably. So, Matt, thank you so much for joining us and for listening to our tough questions and giving great answers to them. Jane, thanks as always. Always a great pleasure to be on with you as well. And listeners, we hope you're hooked enough, at least, that you're going to come back for the next episode, which will be coming in a few weeks.
This podcast is a production of the Hoover Institution, where we generate and promote ideas advancing freedom. For more information about our work, to hear more of our podcasts, or view our video content, please visit hoover.org.